This is Indiana in the Morning, presented by First Commonwealth Bank here on the Voice of Indiana County, WCCS 101.1 FM and AM 1160. Our interviews are presented by Marcus & Mack, a law firm representing injured people, and it is time for martial law. So we want to remind everybody, this radio program is intended to be for informational purposes only. This information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Now, with the legal disclaimer out of the way, we are proud to welcome back onto the airwaves Marshall Chriswell joining us this morning on Indiana in the Morning. Marshall, how you doing?
Good morning, Josh. How are you?
Good to hear from you again, and good to be on the air again with martial law. So this morning you wanted to talk about distribution as far as divorce cases is concerned.
Well, last week I was on, and Todd and I had a discussion about some of the things that people think about divorce cases that maybe aren't necessarily correct, misconceptions about divorce cases. And one of those that we discussed was the fact that a lot of people think when you're going through a divorce that everything that you own and your spouse owns is going to be sold and it's going to be split equally.
Yeah. So
and that's just not the case. And
yeah.
So I thought, that'd be an interesting idea to explore here. In Pennsylvania, when folks get divorced, the law says that property is to be divided by the court, or, of course, by agreement of the parties, but divided by the court, and the distribution is called equitable distribution. So equitable meaning fair.
Mm-hmm.
The court is required to examine, there are 14 different equitable distribution factors, and I won't list them all, but anything from the length of the marriage of the parties, the relative health and earning capacity of the parties, if there are minor children and who's going to be taking care of those children primarily after the divorce. There are all these factors that the court looks at, and what the law says is that the court needs to fashion a remedy that puts both parties in the best possible financial position moving forward.
So some things could be divided one way, and some things could be divided another way. So is everything that somebody has, whether it's like real estate or actual physical property, everything down to, I guess, a DVD collection, is all of that subject to equitable distribution?
So that's the first thing that the court has to do. Is the first step is to identify what is marital property, because only marital property is part of the marital estate. That's the only stuff that's on the table for distribution. So the law says that marital property is everything that the parties have acquired during marriage, so since the time that they were married, which of course doesn't include the period of time that they may have been together prior to marriage, which can often be an extensive period of time. So from the date of marriage up until the date of separation, the date that the parties physically separated. So everything that was acquired during that time is considered to be marital property, with a few exceptions. If something was belonged to one spouse prior to marriage, generally that remains that spouse's individual property that's not divided. So if you owned, say, a husband owned a rental property that was in his name alone, and he never retitled it to joint names with his wife once he got married. Parties get divorced, that rental house is still in his name alone. He gets to keep that investment property, generally free of distribution. So that's one example. Things that were gifts or inheritances from one party's family member that they received during the marriage, as long as they maintained that in their own name. You got a $100,000 inheritance from Great Aunt Betty, and you kept it in a bank account in your name alone. That's going to be your own separate property. So there are some exceptions, but generally everything that you've acquired together during marriage is going to be considered marital property and dealt with in equitable distribution.
Everything in marital property, would that include debt?
It includes debt as well, and that's the same rule applies. If the parties jointly acquire debt, then that debt needs to be equitably divided in the divorce. Now, and again, there are some exceptions. There's some case law out there that supports the fact that if one party took out student loans and graduated, got a degree, and the taking out of those loans and obtaining a degree has increased their earning potential, they may maintain the responsibility for those student loans, things like that. But general household debt, mortgages, credit cards, those kinds of things, all are to be equitably divided as part of the divorce.
Wow. You're listening to Indiana in the Morning, and this is our Martial Law segment with Marshall Chriswell. We're talking about fair and equitable distribution connected with divorce cases. So, Marshall, whenever something comes up like that, what are some of the things that people might think of as a hurdle when it comes to making sure that everything is fair and equitably divided?
Well, so it's very difficult, obviously, to get folks on the same page as to what they believe is fair, and so we always attempt to resolve these cases by agreement, and most cases do get resolved by agreement. And if you can't reach an agreement, then obviously there's a court procedure that you go through, and the court appoints a divorce master where you go in and generally hold a settlement conference and eventually a hearing to determine what all of those what's going to be divided and how. Yeah. So, I had an interesting case that I was dealing with recently that actually is very difficult to get resolved. You have a husband who the marital home where the parties live was his house prior to marriage. He owned it free and clear of mortgage for 13 years. Gets married. The parties are married for about 4.5 years or so, and his wife says, "Hey, why don't you put that house in joint names?" He's not so sure about it, but he agrees to do it. So they retitle the property, put a deed into joint names. 2 months later, wife takes off, leaves the marital residence and files for divorce. And husband of course says, well, hey, this is my house. This is where I'm going to live for the rest of my life. It's been my house for 20 years.
Yeah.
And wife says, well, not really, because you just put it in joint names. So it's a marital asset, and I want half of it. And so those kinds of issues where you're looking at okay, technically, of course, this is marital property because it was transferred to both spouses during marriage, even though it was husband's beforehand. But what's the equitable result there? What's the fair result, right?
Yeah,
because
that's a tough
it really
call.
had only been marital property for about 60 days before the parties separated. So those are the kinds of issues that you've got to look at as lawyers, and the court needs to look at and say, well, yeah, technically, this is by letter of the law, this is marital property, but the equitable distribution statute grants the court great discretion to put the parties on their best footing moving forward.
All right.
And so those, that's just one issue that arises.
Now, I'm assuming that many of the couples who do file for divorces want to get this distribution settled as soon as possible. But suppose it takes a long time. Is there like a hard deadline, like this has to be done within like 3 or 6 months from the announcement of separation or something like that?
No, there's not actually. In divorce cases, number one, in Pennsylvania, there's initially a 90-day waiting period where you can't resolve a divorce case within the first 90 days. The legislature has determined that. But most cases with any that have any level of complexity to them whatsoever, any amount of assets, take a while to get resolved. And sometimes parties can agree on everything and get it resolved in 6 months, but you can't even request the court to hold a hearing until the parties have been been separated for at least 1 year.
Wow.
So these issues take a while to be resolved. I have divorce cases that have been resolved in 4 or 5 months, and I have divorce cases that have where parties owned a small business and investment properties and things that just can't agree that have drug on for 3, 4, 5 years.
Wow. Mm-hmm. So if anybody has any questions about this or any other legal topics, how can they get a hold of you?
You can always give me a call at 724-465-5826. Stop and see us in the R&P Cole building on Church Street in Indiana, or go to the website at www.westernpalawyer.com.
Marshall, this time always seems to fly by, but thanks very much for joining us here on Indiana in the Morning. I'm looking forward to the next segment of Martial Law and what topic you'll have in store for us next time. Thanks again.
Sounds great, Josh. You take care.
You too. Marshall Chriswell with Martial Law here on Indiana in the Morning, presented by First Commonwealth Bank, and all of our interviews are presented by Marcus & Mack, a law firm representing injured people.